Hi guys, and welcome to another episode of Attorney Javier's Philippine Law Lectures for Students. For today's episode, I'll be discussing the remedies for insolvency of individual debtors, meaning natural persons or actual people. Specifically, I'll be discussing the remedies of suspension of payments and liquidation of individual debtors as governed by Republic Act number 10142, otherwise known as the Financial Rehabilitation and Insolvency Act, or FRIA for short. Take note that while I may be giving an overview of some procedural rules, the focus will remain on a discussion of the substantive aspects of the law, meaning the concepts of suspension of payments and liquidation of individual debtors. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. Now let's begin. So today, we'll be discussing the remedies of an individual debtor who is insolvent. When we say individual debtor, this refers to a natural person, meaning an actual person, as opposed to juridical persons. So the remedies I will be discussing today will not apply to business entities such as partnerships and corporations. Aside from these remedies being applicable only to individual debtors, it is also required that the individual debtor must be insolvent. To review, a debtor can be said to be insolvent if its financial condition is such that it is generally unable to pay its liabilities or debts as they fall due in the ordinary course of business, or if it has liabilities that are greater than its assets. Simply put, an insolvent debtor either foresees the possibility that he will not be able to pay his debts on their respective due dates, or they are already actually due and he cannot pay these debts. So what can these insolvent debtors do? Realistically speaking, there are a lot of possible remedies without resorting to legal processes. An insolvent debtor may try to negotiate with his creditors to restructure, reschedule, or set off payments, and many others. But FRIA provides for two remedies that may be availed of by an insolvent debtor, an insolvent individual debtor, namely suspension of payments and liquidation. Let's begin with suspension of payments, which is a remedy that may be availed of by an insolvent individual debtor who wants to but is unable to pay off his debts as they become due. To emphasize, this remedy can only be availed of by an individual debtor, meaning a natural person. So, partnership, corporation, they cannot avail of this remedy. In this situation, the individual debtor has sufficient properties to cover all of his debts. But unfortunately, the debtor foresees that it is impossible or it will become impossible to pay all of his debts as they become due or when their due dates arrive. So here, the debtor is not yet insolvent, he still has sufficient assets, it's just that he foresees that he might not be able to pay his obligations when their due dates arrive. In this case, the individual debtor may choose to avail of the remedy of suspension of payments, in which the debtor files a verified petition to ask the court to order the suspension of or to delay the payment of his debts. Take note that the remedy of suspension of payments does not seek to reduce or to discharge nor to erase the debt. No, the debt still exists and its amount will still remain the same. The sole purpose of a petition for suspension of payments is just to delay or suspend the payment of the debts. So what is needed for a debtor to avail of this petition? Does the law require a certain amount of indebtedness, number of claims, number of creditors before a petition for suspension of payments may be filed? No. FRIA does not set any minimum amount of debts or liabilities, no number of claims, not even a certain number of creditors before a petition for suspension of payments may be filed. All that is required is that the petitioner must be a natural person who has sufficient assets or properties to cover all his debts, but foresees the impossibility of meeting such debts when they respectively fall due. As a side note, you might notice that under the rules of procedure for suspension of payments, specifically Rule 3 of Administrative Matter number 15-4-6-SC, Section 1 thereof of Rule 3 states that the party who can file a petition for suspension of payments is an individual debtor who has assets that exceed his liabilities. However, if you take a look at the substantive law of FRIA, namely RA 10142, this simply requires that the debtor merely possess sufficient property to cover all his debts. Okay, so there is a difference between the two standards. In the procedural rules, the assets have to exceed the liabilities, whereas in the substantive law of RA 10142, it merely requires that the debtor has sufficient property to cover all his debts. Okay? So, it is submitted that it should be RA 10142 that should prevail. Okay? Because it is the substantive law, and therefore, we just follow the standard of the debtor merely possessing sufficient property to cover all his debts. This is because rules of procedure cannot supplant nor prevail over substantive laws. Okay? Now, as for the petition itself, it must establish the jurisdictional requirements. Namely, again, that the individual debtor has sufficient properties to cover all his debts, and he foresees the impossibility of meeting such debts when they respectively fall due, and the relief prayed for must be to ask the court to suspend or delay the payment of debts. Now, the petition must further name at least 3 nominees for commissioner of the creditors meeting, and the petition must be filed in the court having jurisdiction over the province or city where the debtor has resided for 6 months prior to the date of filing. And you can read the list of the necessary attachments to the petition in the rules of procedure, but to name some, the following are some of the essential attachments. No, we have a schedule of debts and liabilities with a list of creditors and their claims, an inventory of the debtor's assets, receivables, claims, and schedule of income and expenditures, and a proposed agreement with the creditors. Now, if the court finds the petition sufficient in form and substance, then it will now issue a suspension of payments order, which will call a meeting of all the creditors that are named in the schedule of debts and liabilities at a time not less than 15 nor more than 40 days from the date of the order. And this order will also appoint a commissioner to preside over that creditors meeting. And this order is similar to the stay or suspension order in rehabilitation proceedings, which we discussed in the previous episode. Particularly, this suspension of payments order preserves the status quo by prohibiting the debtor from making payments other than necessary or legitimate expenses for his business, and also prohibiting the debtor from transferring or disposing of his property except in the ordinary course of business. Okay? This order further prohibits creditors from suing or instituting proceedings for collection against the debtor, except for secured creditors or in case of claims for personal labor, last illness, or funeral of the wife or children of the debtor which have been incurred within 60 days prior to filing of the petition. Okay? Okay? So as I just said, the purpose is to preserve the status quo so that the debtor won't be paying or disposing of his property to the prejudice of his creditors who also want to get paid. Okay? Now, the creditors I just mentioned who fall under the exception, namely the secured creditors and those with claims for personal labor, etc., okay, they may choose not to attend the creditors meeting since they will not be bound by the agreement arrived at in that meeting and are therefore protected anyway. However, if they are aware of this right to not attend and they instead choose to attend, they will be waiving their right already, okay? Because of their voluntary choosing to attend, participate, and vote at the creditors meeting. And if they do attend, participate, and vote at the meeting, then they will be bound by the agreements arrived at the creditors meeting. Now, moreover, if a creditor only incurred his credit within 90 days prior to the filing of the petition for suspension of payments, he cannot vote or attend the creditors meeting. Okay? Now, for that creditors meeting to be held, there must be a quorum. Okay? And what's the quorum? It's creditors holding at least 3/5 of the liabilities of the debtor. These creditors must be present either in person or through a representative duly authorized in writing. Now, during the creditors meeting, the creditors shall present their claims and the commissioner will examine the evidence and the creditors and the debtors shall discuss the proposed agreement. And they can make amendments if necessary before finally voting for either approval or denial of the proposed agreement. Now, if within 90 days from the last publication of the suspension of payments order, either the creditors are not able to make a vote on the proposal or no meeting with the required quorum is actually held, or if the creditors actually vote to deny the proposed agreement, then the court has no choice but to dismiss the petition. However, if instead the proposal is approved by a vote of 2/3 of the creditors with claims representing at least 3/5 of the total liabilities of the debtor mentioned in the petition, then the proposal can now be opened for objections from any creditor who attended the meeting and dissented and protested against the approval of the proposal. So the grounds are defects in the call, holding, or deliberations of the meeting, or fraudulent connivance in the voting of among the creditors and the debtors, or fraudulent conveyance of claims to obtain a majority vote. Okay? So take note, that's a double majority, okay, necessary to approve the proposal. Again, it's 2/3 of the creditors with claims representing at least 3/5 of the total liabilities. 2/3 of the creditors who have claims amounting to 3/5 of the total liabilities of the debtor. Okay, so again, after approval, the proposal will now be open to objections. If the court grants the objections and annuls the debtor's proposal or its amendments, then the petition will be dismissed. But if there are no objections or the objections are denied by the court, then the court will order that the agreement will now be carried out and the parties will be bound to comply with the terms of the approved agreement. So generally, the proceedings should end there. However, the law still grants residual power to the court, which means that upon the filing of the appropriate motion, the court may issue any order which may be necessary or proper to enforce the agreement. Moreover, if the debtor fails in whole or in part to perform his obligations under the agreement or to comply with any order of the court, then the court, upon motion of any creditor, will now declare the agreement terminated, and all the rights which the creditors had against the debtor before the approval of the agreement shall now revest or return to the creditors, and they can now take any available legal action they desire against the debtor. But what if the assets of the individual debtor are not sufficient to cover his liabilities? Then he may no longer avail of the remedy of suspension of payments. Why? Because that remedy requires the debtor to have sufficient assets to cover his debts, only that he foresees the impossibility of meeting such debts when they respectively fall due. So in this case, what can the debtor or his creditors do? In case the properties of the individual debtor are not enough to pay his liabilities, specifically, in case the debtor owes debts exceeding 500,000 pesos, then he may avail of the next remedy, liquidation. Again, the discussion for today only applies to an individual debtor, meaning a natural person. Okay, and not a partnership or corporation. Especially because some requirements needed to file a petition for liquidation are different for these juridical debtors. And we will talk about voluntary and involuntary liquidation of juridical persons, meaning partnerships and corporations, in the next episode. Okay? So for today, what is liquidation? Liquidation refers to proceedings where claims are filed and assets of the insolvent debtor are disposed of, and the proceeds thereof are now divided among the creditors. Similar to rehabilitation, which we discussed previously, liquidation may be voluntary or involuntary. Voluntary liquidation, as the name implies, refers to liquidation proceedings that are initiated by the debtor himself of his own free will. However, unlike suspension of payments, where the debtor is not discharged from the debt but is merely asking the court to delay or suspend payment of his debts, by availing of voluntary liquidation, the debtor is applying to be discharged from his debts and liabilities. Thus, through liquidation, the debtor can be discharged from his debts by the sale, transfer, or other disposition of his unencumbered assets to convert the same into money, which money will then be used to pay the creditors in accordance with a liquidation plan approved by the court. Alternatively, instead of being sold, specific unencumbered property may also be conveyed to a creditor in satisfaction of his claim in whole or in part. Voluntary liquidation is initiated by the debtor by his filing of a verified petition with the court of the province or city in which he has resided for 6 months prior to such filing. Okay? Now, the law has a list of what must be written and attached to the petition, and you can just go over that, no? Or you can leave it to your lawyer. But the following are some of the more important matters, no? In the petition, the debtor must name at least 3 nominees to the position of liquidator and attach a schedule of debts and liabilities with a list of creditors and their claims. Also, an inventory of assets, including receivables and claims against third parties, and a schedule of income, among other requirements. Take note that this act of filing a petition for liquidation shall be considered as an act of insolvency on the part of the debtor. Now, if the court finds the petition to be sufficient in form and substance, then the court will now issue a liquidation order within a maximum period of 10 working days from the filing of the petition, and then proceedings will commence. Now, what if the debtor is insolvent, but he's not taking any steps to take care of his debts? This is where involuntary liquidation may apply. Thus, where the insolvent debtor fails or refuses to act, the law allows any creditor or group of creditors with a claim or aggregate claim against the debtor of at least 500,000 pesos to file a verified petition for liquidation with the court of the province or city in which the individual debtor resides, alleging any of the acts of insolvency of the debtor, And I'll give some examples such as the debtor is about to or already has departed from the Philippines with intent to defraud his creditors. Or the debtor has concealed himself or his property to evade payment or legal process for collection. Or the debtor may have transferred or disposed of his property with intent to delay or evade payment or otherwise defraud creditors. And you may read more examples of acts of insolvency which must be alleged, no, in section 105 of FRIA. Additionally, the petition must be filed with a bond, condition that if the petition is dismissed or withdrawn, or if the debtor be declared as not insolvent, then the petitioners will pay all expenses, damages, and attorney's fees caused by the proceedings. Now, once the petition is filed, okay, the court will now issue summons requiring the individual debtor to show cause why he should not be declared insolvent. Okay? And any creditor may also file a motion asking the court to prohibit the debtor from making payment of any debts or transferring any of his property to the prejudice of the creditors until the court issues a liquidation order or dismisses the petition, whichever comes first. Nevertheless, even if such motion is granted, secured creditors will still be allowed to enforce their respective liens against the debtor. Now, what if the debtor is not currently present in the Philippines? Especially if he is in hiding to defraud creditors or to avoid receiving the summons. No problem. Proceedings under the petition may still continue, and the creditors can simply file a motion asking the court to direct the sheriff to take and hold property of the debtor as much as may be necessary to satisfy their claims and the cost of the proceedings. And these properties will be held by the sheriff or the court for the benefit of all the creditors, who will then prove their respective claims before the court in the proceedings. Okay? Now, this motion must be accompanied by affidavits showing that the continued absence of the debtor is with intent to defraud his creditors, as well as a bond in double the amount of the aggregate sum of their claims to answer for the damages which the debtor may suffer in case the petition will be dismissed. But if the debtor is in the Philippines, then proceedings will simply continue, where the court will determine the propriety of issuing a liquidation order. And this liquidation order is important because of its contents and its effects. No? It declares the debtor insolvent, it sets the case for hearing for the election and appointment of the liquidator, it orders the liquidation of the debtor by vesting legal title and control over the assets in the liquidator. It directs the payment of claims due to the debtor to the liquidator and directs creditors to file their claims with the liquidator and prohibits the debtor from making payments or transfers of his property, among other orders and effects. And you can just read the law for the full list of contents and effects of the liquidation order. Just note that the liquidation order will not affect the rights of a secured creditor to enforce his lien unless, of course, he waives his right in writing before the election of the liquidator. Now, as I said, I won't go into detail anymore about procedural matters such as the election, removal, qualifications, powers, duties of the liquidator, and other matters, no? But I can give an overview of what happens after the court issues the liquidation order. So, the creditors will now file their claims with the liquidator, who will then submit a liquidation plan to the court for approval. That liquidation plan will enumerate the assets of the debtor that are not exempt from execution, a list of all the creditors and their respective proven claims, and a proposed mode and schedule of liquidation of assets and payment of the claims. After the court approves the liquidation plan, it will then be implemented, ensuring that the rules on concurrence and preference of credit under Philippine laws are observed, unless a preferred creditor voluntarily waives his preferred right. Now, with the approval of the court, the liquidator may now sell, transfer, or otherwise dispose of the unencumbered assets of the debtor to convert the same into money. As a general rule, the sale must be at a public auction, although the court may approve a private sale if the goods are perishable, disproportionately expensive to maintain, or if it is for the best interests of both the debtor and his creditors. The court may also allow specific unencumbered property to be conveyed to a creditor in payment of whole or part of his claim. Now, after the sale, the proceeds will be distributed to the creditors in accordance with the liquidation plan. Thereafter, the liquidator will submit his final report and accounting to the court, which, if the court is satisfied with the final report, the court can now discharge the liquidator, issue an order approving the final report and discharging the debtor from the liabilities listed in the liquidation plan, and terminate the proceedings. Okay? So take note that this is only a general overview of how the proceedings may go. Okay? So filing of the petition, then issuance of the liquidation order, the submission of claims, determination of claims, the submission and approval of the liquidation plan, implementation, then distribution of proceeds, okay, according to the plan, and then termination of the proceedings. Okay? So definitely there are some omissions, no? Such as in case of objections, etc. But these are things that you can leave up to your lawyer if you are the insolvent debtor, or you can study on your own if this is a subject that you are studying. Okay? So that's it for the remedies of the individual debtors under FRIA. To review, a natural person may apply for suspension of payments if they have sufficient properties to pay for their debts, but they foresee the impossibility of paying the debts as they fall due, and in which case the debtor is not asking to discharge, erase, or reduce the debt, but only to delay or suspend the payment of such debts. If he does not have sufficient properties, then he may also choose, or his creditors may choose, the remedy of liquidation, in which the assets and properties of the debtor shall be sold and the creditors will be paid from the proceeds. Okay? So I hope you may have learned a thing or two about these remedies, and I hope to see you soon. Okay? See you next time, guys. Bye.